Salusia, we are good to go now. Okay. So, yanzu malam za su hau. Your attention. I've not even mentioned. I sent you a message. I called you severally. I tried to reach out to you yesterday. Somebody gave me your number. You're not doing me a favor by answering the call. Honorable Commissioner, sir.
President shege ne ba. Akwai barkatai family program ɗin shi ne ke faɗa. Wannan har yanzu wani ajiyar corrections tana ganin su?
job you are supposed to do. So check your phone first of all. Well,
Ya kawo mu kafin wanda zan yi yin da zai shi.
Zai kawo.
your attention. I'm not even mentioned. I tried to reach out to you yesterday. By answering the call, Honorable Commissioner Sam, you're doing your work. I'm not asking you about your wife and children. Continue, madam. What are the ambush? I said that message. But yesterday, I call up, this morning, I call up again, I sent that message before I entered.
The phone number you're trying to call is not reachable at the moment.
See the reason why they recall it. And you want to take shout, be able to check the record of who is being
Hello? Usman ne ce ka kawo ma ina ofis ka kawo mun abin nan yarin notice ina ofisin man sai. So.
Usman, haɗin da mutum da baya wasa da aikin shi sam.
Na?
Na ce baya wasa da aikin shi.
To daidai kenan.
Akwai wancan.
Ba dama abin da ya kamata. Wallahi ka riga ka karbi aiki din. Ka rinka yin abunka. Ya gwargwado. Mutane ba san me ba su ba sa tunanin su awas ɗin.
I'm having challenges with my installation. Okay. Good morning.
Good morning, my noble.
Please, can you call the case?
Nigeria, and Sani Muhammad Alasan, aka Sani Bagu, and Mohammed Isa.
The presentation. Yes,
my lord. The first defendant is well, the second defendant is at the correctional center.
Correctional center. Can you unmute your device? Correctional center. The process of unmuting. Can you unmute your device? Correctional Center, your device is muted. Can you hear us? B. Shaibu, are you still there? Correctional Center. Good morning.
Good morning, my lord.
Okay.
The defendant
present. Okay, thank you. Representation.
With respect to my lord, I am Usman Bamana. My home is for the complainant.
The Defense Counsel. If he's having challenges, let him come back to the court. Mr. Audu. Okay. Quickly, please. Can you unmute yourself? Be sure, okay.
Yes, my lord. Yes, my lord.
We have been waiting for you since.
Okay, sorry, my noble lord. With respect and humility, my noble lord, I am B. Shuaibu. I'm appearing for defendants, my lord.
Yes.
Yes, my noble lord, the matter is for adoption of final written address, and we are ready to proceed with same. The matter is for adoption of final written address, and we are ready to proceed with same, my noble lord.
Yes.
Yes, my lord. My lord, the
My lord, are you ready?
Yes, go ahead.
Thank you, my lord. My lord, the defendant final written address dated 8th day of February 2024. Dated 8th day of February 2024 and filed on 12th day of February 2024, my lord. My lord, We formulated sole issue for determination, my noble lord. We formulated two issue for one sole issue for determination, my lord, which is converse with each of argument, my noble lord, converse with each of argument. My noble lord, we adopt same as our argument and urge this honorable court to so hold, to discharge and acquit the defendants, my noble lord. To discharge and acquit the defendants, my noble lord. Thank you, my noble lord.
Yes.
My lord, we have carefully gone through the final written address filed by the counsel to the defendant. My lord, in our careful perusal, my lord, we deem fit to reply on point of law, my lord, by referring this court to just two authorities.
Yes.
My lord, it is our humble submission that the defendant is trying to enter defense at the time of filing their written address, my lord. My lord, it is at this juncture we didn't fit to refer this court to the case of Mojid versus the state, my lord. 2020 Law Pavilion Electronic Law Report. (49900) Court of Appeal.
49900.
Court of Appeal, my lord.
Yes.
My lord, and also the case of ONYEBUCHI. But
Yes.
was the state. With the leave of my lord, I read on whether the defense in criminal matter must challenge all the evidence it wishes to dispute by cross-examination and not at defense, my lord. The law is perfect in all the evidence it wishes, the evidence it wishes to dispute by cross-examination when the prosecution is still in the witness, and this is the only way to attack evidence lawfully admitted to the trial. It is late at the close of the case for the prosecution to attempt what was left unchallenged. My lord, it is on this view, my lord, we humbly submit that the defendant, my lord, did not challenge, did not debunk evidence of the prosecution, my lord. My lord, and same was corroborated by the DW2, my lord. Sorry, my lord, not DW2, my lord, the second defendant, my lord, sorry. Second defendant. It was not challenged. And my lord, the defendant did not declare that witness, my lord, as hostile or tainted, my lord. My lord, and it is the general position of the law that silence means admission in our evidence law. My lord, last but not the least, in the case of Ode versus the Federal Republic of Nigeria, 2016. In 15 Nigerian Victory Report, part 1536. At page 363 to 387.
36.
To 387, my lord. My lord, with the leave of the court, and the prosecution is not bound to prove facts within the knowledge of the defendant. It was submitted that the prosecution is not bound to prove negative assertion as well as facts within the personal knowledge of the accused person, which is the defendant, my lord. My lord, from the totality, my lord, of the written address filed by the counsel to the defendant, are facts within the knowledge of the defendant, my lord, which may be true or not. These are this juncture, my lord. We urge my lord to convict the defendant as charged, my lord. Thank you very much.
Ruling.
Court, please, my lord.
This case is called. The first defendant is in court while the second defendant is at the Potiskum Correctional Center. This proceedings, which is by virtual mode, it's a combination of the traditional and the virtual mode to enable the second defendant to be present in court. Judgment will be delivered shortly.
That's court, please, my lord.
Judgment. The defense counsel are still there? B. Shaibu.
Yes, my lord. I'm with you, my lord.
Judgment.
As the court pleases.
The defendants in this case are Sani Muhammad Al-Hassan, aka Sani Babu, and Muhammad Isa, aka Bulama. They were arraigned before this court by the National Drug Law Enforcement Agency, NDLEA, Yobe State Command on a two-count charge number FHC CR 7/2021, dated 29th July 2021, and filed the same date by the NDLEA against the defendant. The charge reads that you, Sani Muhammad Al-Hassan, and you, Muhammad Isa, male adults of Filin Pono Gashua, but the local government area of Yobe State on or about the 21st and 24th days of July 2021, at both Filin Pono and Garilla Mido Gashua within the jurisdiction of this honorable court, without lawful authority, conspired amongst yourselves, possessed and dealt in 387 grams of suspected cannabis sativa psychotropic substance, a substance similar to heroin, cocaine, and LSD, and thereby committed an offense contrary to and punishable under Section 14B of the National Drug Law Enforcement Agency Act, Cap. and 40 laws of the Federation of Nigeria, 2004. The defendants pleaded not guilty to the charge when they were arraigned on the 30th September 2021. Trial commenced. At the trial, the prosecution called 3 witnesses and tendered the 387 grams of suspected cannabis sativa and other documentary exhibits. The case of the prosecution is summarized below. PW1 Ukaga George C. is an officer working with the NDLEA for 25 years as superintendent of narcotics by rank. The officer identified the second defendant by name Bulama Mohammed Isa and testified he was among the NDLEA operatives that arrested the first suspect, herein referred to as second defendant, who was caught with 97 wraps of cannabis sativa, popularly called Indian hemp, on 4th July 2021, and was taken to the office at Gashua and handed over to the exhibit officer, who field tested the exhibit, and it proved positive for cannabis sativa. The defendant was detained pending the outcome of investigation, and that while in the cell, he was making noise, shouting that his master ought to bring him water, as a result of which he was brought out of the cell to be interrogated. In the course of interrogation, he mentioned the name of his master, Sani, second suspect, herein referred to as the first defendant, Sani Al-Hassan Bagu, as the owner of the exhibit. PW1 testified that on a follow-up operation on the 24th July, they went to the first defendant's house, that he ran away and was pursued, arrested, and taken to their office in Gashua. That while passing by the cell, the second defendant, on sighting the first defendant, started saying, "Oga, I'm here." The first defendant was taken to the investigating room, where he confessed that truly the second defendant is his boy, and he gave him the Igbo to sell. The defendants were cautioned and volunteered confessional statements and were transferred to the state headquarters in Damaturu. PW1 testified further that he too gave a statement. PW1 was therefore cross-examined by the defense counsel, B. Shaibu, where he confirmed that he witnessed the arrest of the first defendant near his house at Gashua area near cemetery in Gashua, while the second defendant was arrested in a joint with 97 wraps of Indian hemp in Gashua before it was sent for forensic analysis in Lagos, where the first suspect was arrested on 21st July and follow-up done on 24th July on confession of the first suspect, who pointed out the second suspect's house under what was called cover, where he was pursued and arrested, while the first suspect was arrested at a joint where he carries his trade, not at a house. The witness was asked, remember, during examination in chief, he informed the court that the first defendant said, "Oga, I'm here," and now you're saying something else. Which do you want the court to believe? He replied, the first defendant was arrested, mentioned the name of the second defendant in a cover in the evening. When he went to cover the second time, nothing was recovered. In answers to questions put under re-examination, PW1 told the court that a field testing was done wherever there's arrest in area command. The confirmation of field tests is in Lagos, and was further asked, you refer to first defendant as Bulama. Is he Mohammed Isa? The witness affirmed the man that was vomiting. PW2 Bagudu David, this is an NDLA officer, a superintendent of narcotics, and the exhibit keeper officer attached to the Yobe State Command. He has been with the agency for 11 years. His duties as the exhibit officer included receiving exhibits arrested with the suspected offenders, testing drug exhibits, weighing them, issuing exhibit forms, which include certificate of test analysis form, packing of substance form, and request for scientific aid form, keeping the custody of such exhibits, and also testifying in court in respect of the exhibits. PW2 testified that on the 18th June, the defendant was brought before him by PW1 and PW3, along with a black polythene bag, to which he opened the bag in the presence of the defendant and discovered dried weed suspected to be cannabis sativa. The witness stated that he informed the defendant that he wanted, the second defendant, that he wanted to carry out a test, and the second defendant affirmed, to which he took a sample of the dried weed and carried out a test, which test proved positive for cannabis sativa. He also weighed the dried weed, and it weighed 387 grams in the presence of the defendant and the arresting and witnessing officers. The witness testified further that he packed the exhibit into two parts, A1 and A3. After taking a sample from the exhibit and labeled the A1 with a number NDLEAYBSC 014-2021 with the name of the exhibit, dried weed substance, the defendant's name, PW2's names, PW1 and PW3's names, whereby the defendant imprinted on the exhibit forms in the presence of the arresting and the witnessing officers, who also signed. The witness testified that he sealed the A1 in a transparent evidence pouch and sent it alongside with the request for scientific aid form to Lagos for scientific analysis. He also packed the A3, which is the bulk of the exhibit, and labeled same NDLEAYBSC 014-2021 with the defendant's name, the name of the exhibit, the weight of 387 grams, and kept the exhibit in the exhibit's room under lock and key. At a later date, he returned to the forensic unit and Lagos and collected a large brown envelope with the drug analysis report number NDLEASD 2021-13-21 and the request for scientific aid form attached. He returned to Damaturu with these documents and kept them under lock and key and brought them to court. The bulk of the exhibit forms, and the large brown envelope containing the analyzed exhibit and drug analysis report were all admitted in evidence through this witness in evidence at the trial. Under cross-examination, PW2 confirmed that he did not know where NDLEA Sani 4 was recovered, and he was not the maker of NDLEA Sani 4 drug analysis report. And when further asked by the defense counsel whether he was informed by their personnel that the defendant was arrested with NDLEA Sani 4, the witness answered that nobody informed me. The defendant was brought before me by the arresting and witnessing officers, that the suspects were brought before him, that he was not at the scene of the arrest of the defendant, and that it is true that he does not know where the defendants were arrested with the bulk of the exhibit. PW2 stated that he arrived the NDLEA headquarters on the 9th and 10th, received the result which, on the 9th and on the 10th, received the result which the expert conducted, the drug analysis, and he was not the witness that did the drug analysis report. His own was the preliminary test and sent it to expert for analysis. And when he conducted the test, it proved positive. PW3, Davis Bambis. This is an NDLEA officer working with the Yobe State Command for 22 years, a chief superintendent of narcotics, that he knows the defendants before this court, that on the 24th July 2021, in Garin Lamid, Ogashua, he led a team of officers around 6:30 p.m. and arrested Bulama Mohammed Isa. From there, he was brought to the office with a dried weed substance suspected to be cannabis sativa, which was tested and it proved positive for cannabis sativa and weighed 387 grams. That he volunteered his statement and accepted ownership of the exhibit, that it belongs to his master, that is Sani Bagu, the first defendant. While in detention, he said he's not the owner, he sells for one Sani. On the 24th July 2021, around 6:30 a.m., the witness led a team of officers to Garin Lamido, Gashua, and Therefore, and before reaching the house, the first defendant was alerted and he ran away. The house was searched and he was arrested in a nearby house where he was hiding there. And that was how he was arrested and brought to the office, where that same exhibit was brought before him, and the first defendant who said, and the second defendant who said that he is my master. That exhibit was weighed in his presence, and it weighed 387 grams, and he accepted ownership of the exhibit as the real owner. That the second defendant is a sales boy. He did not deny him, and he went ahead and volunteered his statement. The prosecuting counsel asked the witness, in your testimony, you stated taking statement of both first and second defendants, to which the PW3 responded, yes. The dates differ as they were arrested separately. Yes, the first defendant printed on the statement, same with the second defendant's statement. Yes, if I see both defendant statements, I'll be able to recognize by my handwriting and signature. During cross-examination, the PW2 confirmed that upon tendering the statement of the defendants, it was not signed, and that he was around during the operation that led to the arrest of the defendants. The witness also affirmed that he does not know the first defendant until when the second defendant identified him, and that he was also informed by the second defendant that the exhibit belongs to his master, the first defendant. The exhibit tendered and admitted in evidence in support of the prosecution's case was also reviewed as follows. Exhibit NDLEA Sani 1. This is the statement of the witnessing officer, Ukaga Judge C, dated 21st July 2021. Exhibit NDLEA Sani 2A. This is the certificate of test analysis form on which PW2 stated he wrote the result of the preliminary test he conducted on the drug exhibit, NDLEA Sani 4, brought to him by PW1 along with the defendant. He stated in this form that he tested the sample of the suspected substance with the United Nations testing kit and found it to be positive for cannabis sativa. The form was printed by the defendant as a suspect, while the PW1 and PW3 signed the form as witnesses of the preliminary testing. Exhibit NDLEA Sani 2B. This is another NDLEA form named packing of substance form. The substance stated in this form is cannabis sativa. This exhibit was divided into two parts and labeled A1 and A3 respectively by PW2. The A1 was the bulk of the exhibit and A3 was the sample put in an evidence part for expert analysis. The form was printed by the defendant and signed by PW2 as the maker. PW1 and PW3 signed as witnesses of the divisions of the exhibit by PW2. Exhibit NDLEA Sani 2C, this is the NDLEA form named Request for Scientific Aid form. This form accompanied the sample of the exhibit A3 to forensic unit for analysis in Lagos. It has the name of the defendant, it as the suspect. It carried the laboratory number given to the exhibit by the analyst, and it was endorsed by both PW1 and PW3, as well as the PW2 who filled it to accompany the sample, and he took to forensic unit in Lagos. Exhibit NDLEA Sani 3A. This is the drug analysis report written by the forensic analyst that conducted the analysis in Lagos, confirming that the exhibit A3 hand-delivered by the exhibit officer has tested positive for marijuana cannabis. Exhibit NDLEA Sani 3B. This is the transparent evidence pouch containing the remnants of the analyzed exhibit from forensic analysts attached with the request for scientific aid form. See the evidence of PW1, PW2, and PW3 above. A sample of the dried weed in a transparent evidence part with the case and exhibit number, the weight of the exhibit, name of the defendant, and names of PW1 and PW3 as witnessing officers. Exhibit NDLEA Sani 3C. This is a large brown envelope in which the forensic analyst enclosed a sample of the exhibit NDLEA Sani 3B, which he analyzed and addressed to the PW2 with reference number NDLEA YBSC/014/2021 and drug laboratory number NDLEA/SD/2021/1321 written there. Exhibit NDLEA Sani 4 is the bulk of the exhibit A3, which is the dried with substance weighing 307 grams amounting to 97 wraps, concealed in a black polythene with a case number NDLEA YBSC014/2021 with the name of the defendant and the names of PW1 and PW3 as witnessing officers. Exhibit NDLEA Sani 5A and 5B. This is the extrajudicial statement of the first defendant recorded by PW3 in Hausa language and the translated version dated 21st July 2021. Exhibit NDLEA Sani 6A and 6B. This is the statement of the second defendant as recorded by the PW3 in Hausa language and the translated English version dated 21st July 2021. At the close of the prosecution's case, both defendants chose to give evidence in their defense as DW1 and DW2 respectively. The case of the defense is summarized below. DW1 Sani Muhammad Al-Hassan, aka Sani Bagu. The defendant resides at Gashua, Yobe State. And he deals in livestock by selling animals at village markets. That what transpired on the 4th July 2021 between him and personnel of NDLEA is that the officials of NDLEA went to his house in his absence, searched and did not get anything. After 3 days, while working, he was arrested and taken to their office and informed that what Bulama, the second defendant, was arrested with belongs to him. That the DW1 insisted that the goods belongs to him, that at the office a document was brought to, and one of the personnel held his hand and placed it on the document to thumbprint. That he was not asked anything apart from his stay in Lagos, that he was questioned about his biography, and he also informed them that he married off 2 of his children. From there, they were brought to Damaturu, where he was asked what transpired at Gashua, and he explained everything to them. And they were taken to court because this court was on vacation, and they spent 100 days at Potiskum Correctional Center before being brought to this court, and thereby pleaded for the court to discharge him. When the DW1 was asked under cross-examination whether he was asked about his biography, which he gave in writing, DW1 answered, they did some writings. He was further asked from his recorded statement, he's 54 years old from the family of late Mala Al-Hassan, to which the DW1 stated that no, we did not discuss that. And when further asked, were you the only one living in the territory? You were arrested, the witness answered, I was on foot walking. I was the only one. I was about to go and call my Rua when I was held at the back by NDLEA. That there was no any misunderstanding between him and the NDLEA, that the exhibit does not belong to him, as the second defendant connected him to the case. When asked, are you denying the second defendant now? DW1 answered, how? What I don't know, I cannot affirm. My connection with the second defendant is that we live in the same area. The prosecuting counsel asked him, you engage in the business with the second defendant where you supply narcotics to him and he sells for you. DW1 answered, I do not have an idea on that. When further asked, your co-defendant is in custody while you are enjoying, the witness replied, yes, it does not belong to me and not found with me. The witness was reminded that the second defendant is watching and he's going to testify as well, and whether there's any misunderstanding between them, to which he replied, no misunderstanding. And how can the second defendant know only me in our area? Yes, he knows a lot of other people. It is a new settlement. DW1 was further asked, tell the court why you, amongst all members in your area, as one, the second defendant insists, sponsored him and asked NDLEA to arrest you. He answered, I do not know. When further asked, do you know that the scene you generated on second defendant can flow on you? The witness replied, I believe that whoever causes harm to the other, God will recompense him. Allah zai saka masa. DW2, Mohammed Isa. The defendant, the second defendant is a fish seller and a farmer and resides at Gashua, Yobe State. When asked to cast his mind back to 24th July 2021 and tell the court what transpired between him and NDLEA, he testified that he and Mohammed Sani Al-Hassan, first defendant, live in the same area, that the first defendant has a boy who sells taba to him, and on each Maulid Salah day, when the boy traveled, the first defendant called him that the witness should assist him to keep the exhibit as the boy was not around. That in the evening, the NDLEA arrested him and took him to their office where he was asked who owns the exhibit. That the first defendant called the commander on phone and spoke to him in Hausa language, while the commandant does not understand Hausa language. And Davis, PW3, collected the phone and put him on, and the first defendant asked Davis, why seize my goods on Salah day when I used to pay for this? That Davis answered back that since you are proud to say that you pay us, then you will be reported. That the first defendant told him that since you said you will report me, I will call the local government chairman to report you. To which Davis answered, report me not only to local government chairman, tell Ahmed Lawan, the number 3, since he's not the one that employed me in this job. That Davis insisted that he would take the matter up since the defendant is so arrogant. And that the first defendant told him that wherever you take me, since it's a matter of money, I will come out. That after that, Davis called the first defendant, but he refused to come. They followed him since he refused to come and arrested him at his house. And that when he was brought to the office, he was shown the exhibit that the second defendant was arrested with and asked who owns it. And he said it belongs to him, and they wrote it down. The second defendant testified further that much later, the first defendant told him that he will try and see that they are both released on bail. The DW2 testified further that Davis told them that the statement earlier made by them, they have to forward the matter. And the first defendant stated that it is a matter of cash. So even in Damaturu, he will get a counsel to bail him out. That they were brought to Damaturu at NDLA office where both defendants were asked as to who owns the exhibit, and that the first defendant admitted ownership of the exhibit. And they were informed that they have heard what the first defendant said earlier, pride and arrogance, so nobody will bail him out and he'll be taken to court. Thereby, they spent 3 days in custody, as at that time, this court was on vacation, and they were taken to a magistrate court and then taken to correctional center. The witness testified further that at the Patiskum Correctional Center, the first defendant told him that he will engage in services of a lawyer, services of counsel, and that he told him that having discussed with his lawyer that if asked, they should deny the knowledge of the exhibit in court, and he told DW2 that if he agrees that they should both deny, then he will ensure that they are granted and released on bail. But if the DW2 refuses, he will leave him there. And that at the court, the first defendant was released and the witness was left in the Potiskum Correctional Center, like he told him, since he has no one to take him on bail. The witness testified further that after the first defendant was released, he met the second defendant's relatives and solicited for money for the sum of 40,000 naira, which he collected, but kept the money without looking out for the second defendant, whose wife is a tenant in a rented house, was kicked out. Defense counsel interjected to stop the second defendant. The second defendant insisted on telling the court in detail what happened, on the situation that he finds himself to date. And when asked by counsel, what do you want the court to do for you? He stated thus, for 30 months, I've been in prison. I plead with the court to look at the situation I'm in. I plead for the court to be lenient, taking into account the current circumstances I and my family are facing. Nashiga de Iyalaina, I plead that this is the first and last time I plead for mercy, as this is not by vocation. Harka. During cross-examination, DW2 was asked, in your testimony before the court, he informed the court that you and the first defendant have confessed the truth in your statement at NDLEA, to which he replied, true. Yes, it was in writing. The witness was further asked, if you see the statement in writing, if you see the statement of the first defendant and yours, will you identify same? And he replied, I can't read. He was further asked, I will read it out, but if you see the statement sheet, will you recognize it? I will read it out, but if you see the statement sheet, will you recognize it? The witness replied, I cannot recognize, but I can understand what was written. The prosecuting counsel asked the DW2 to tell the court what the first defendant told the court. Was it true or lies? And he answered, what he told the court is not true. At the conclusion of hearing, the matter was adjourned to today to enable counsel file and exchange their final written address. The defense counsel adopted his written address while submitting a sole issue for determination. The prosecuting counsel addressed the court on points of law, and the matter was consequently immediately adjourned for judgment now. Above is the summary of the prosecution's case and defense put up by the defendant on the charge. In criminal trials, such as this one, it is the duty of the prosecution to establish the guilt of the defendant of the offense charged beyond reasonable doubt to secure a conviction. See Section 135, 1 and 2 of the Evidence Act. On the burden and standard of proof in criminal cases and ways of proving the commission of a crime, guilt of an accused person, the Supreme Court held in Ari Gbigbola Awoshika versus State 2018 LPLR that it is well-settled principle of law that an accused person arraigned before any court of law is presumed innocent unless and until he is proved guilty by his accusers beyond reasonable doubt through credible and reliable evidence. See Olainka Afolalu versus State 2010, 16 NWLR, Okoro versus State 1988 NWLR, Bakari versus State 1957, 3 Supreme Court, etc. It needs to be added that the burden of proof does not shift. Once there's the slightest doubt in the mind of the court, such doubt must be resolved in favor of the defendant, who should subsequently be acquitted by the trial court. The defendant is charged under Section 14 sub B of the National Drug Law Enforcement Agency Act, N40, Laws of the Federation of Nigeria, 2004, which provides that any person who conspires with, aids, abets, counsel, attempts to commit, or is an accessory to any act or offense referred to in this act shall be guilty of an offense under the act and liable on conviction to be sentenced to imprisonment for a term of not less than 15 years and not exceeding 25 years. In this case, the defendants are charged of being in unlawful possession of 387 grams of dried wheat, which has tested positive for marijuana, cannabis, Indian hemp, a drug that is similar to cocaine and heroin. Being a criminal trial, the onus, as stated earlier, is on the prosecution to establish the guilt of the defendant by proving all of the ingredients of the offense charged. The prosecution is not relieved of this burden, even where the defendant had admitted the commission of the offense. This was held by the Supreme Court in the case of Busari versus State 2015, where it followed its earlier decision in the case of Agbadion versus State 2000, 7 NWLR, see also Section 135 of the Evidence Act 2011. Therefore, this Honorable Court will adopt the issue for determination as was submitted by the Defense Counsel in this case in their final written address, which is whether from the totality of the evidence placed by the prosecution before this court, the prosecution has proved its case against the defendants beyond reasonable doubt. To determine whether the charge has been proved against the defendants beyond reasonable doubt in view of the evidence called by the prosecutions, calls for a review of the prosecution's case, prosecution's witnesses' testimony, which shows that the second defendant was arrested in possession of the illicit dried wheat, to which he denied ownership and claimed that it belongs to the first defendant. The exhibits were taken to Lagos to the NDLEA laboratory for forensic analysis, which result confirmed that the dried wheat substance has tested positive for marijuana, cannabis. Thereupon, the prosecuting counsel tendered the bulk of the exhibit recovered as evidence before this court, which the court admitted into evidence and marked it as NDLEA Sani 4. The PW1 and PW3 testified on the circumstances of the arrest at different times of both defendants. The question is, can the evidence of the prosecution witness on the circumstances of the arrest of the defendants be enough to establish the offense that they are charged with beyond reasonable doubt? The evidence of PW1 and PW2 on the mode of arrest of the defendants and on how the exhibits were found were corroborated to a large extent by the extrajudicial statements of the defendants, starting with the extrajudicial statement of the first defendant, which reads thus: I, Sani Mohammed Al-Hassan, aka Sani Bagu, having been duly cautioned, freely volunteered to state as follows, and also authorized this officer by name Davis Bambis to write my statement on my behalf because of my inability to write. And the statement was also taken in the presence of my friend Bala Ahmed. I was born 54 years ago from the late family of Madam Al-Hassan Mayungwa and Mrs. Fatima Mayungwa. I only attended Islamic education. I'm third child of my parents out of 4. I only attended Islamic school from 18 years. From there, I traveled for 18 years. From there, I traveled to Oshodi, in Lagos State, where I'm dealing in livestock business, but have to come back home after the death of my mother 7 years ago. I'm now in Gashua living with my one wife and 13 children. I just gave out 2 of my daughters in wedding last 2 weeks in Gashua. Today being 21st day of July 2021 at 6:30 a.m. while sleeping in my house, somebody called and alerted me that NDLEA officers are coming to my house. And I ran away, but was later arrested nearby my house, and I was brought to the office here in Gashua, NDLEA command, where I met Isa Mohammed, aka Bulama, who was arrested by the same NDLEA on Saturday around 6:30 near house where he's selling Indian hemp for me. I personally gave him the drugs to sell for me. I did not deny it. He is my boy, and I have been dealing in Indian hemp for the past 17 years, and I was told by Nasiru Ajik, while in the office, the exhibit was tested and proved positive for cannabis sativa, weight 307 grams, all done in my presence and other officers. And I signed and printed some forms and volunteered my statement under caution. And I was also arrested last year, 2020, in connection with Indian hemp, where I was arrested with about 2 blocks and some quarter of Indian hemp, but due to my illness, I was warned and allowed to go based on medical ground. The extrajudicial, that's the end of the extrajudicial statement of the first defendant. The extrajudicial statement of the second defendant reads thus: I, Isa Mohammed, was born some 48 years ago from the families of Isa Lawan and Mrs. Aisha Lawan, all of Garin Lamido in Gashua local government area of Yobe State. I'm the 5th child of my parents out of family of 11, and I only attended Islamic school in my life for 7 years in Gashua. Then I started my fishing and farming, and I'm also married to a wife and 6 children, all living with me in Garin Lamido, today being 21st day of July 2021 at about 18:30 hours in Bosheri, where I'm selling Indian hemp, where I was arrested by NDLEA and brought to their office along with my exhibit, where I confessed that the exhibit belongs to me, but was given to me by Sani Bagu to sell for him, who is my master. While in the office, the exhibit was counted to be 97 wraps and was field tested and proved positive for cannabis sativa, weight, all done in my presence and other officers, and I signed and printed some forms, and I volunteered my statement under caution. I note, that's the end of that statement. I note that the extrajudicial statement of the first defendant was objected to when the prosecuting counsel sought to tender same at the trial, to which the court adjourned and overruled the objection of the defense counsel in a considered ruling, and both the Hausa and English translated version were thereby admitted as NDLEA Sani 5A and 5B. Likewise, the extrajudicial statement of the second defendant was also tendered into evidence as NDLEA Sani 6A and 6B without any objection. Although the first defendant retracted his statement by testifying in court thus, that at the office a document was brought and one of the personnel held his hand and placed it on the document to thumbprint, that he was not asked anything apart from his stay in Lagos, that he was questioned about his biography, and he was also informed, them that he married off 2 of his children. When the DW1 was asked under cross-examination whether he was asked about his biography, which he gave in writing, DW1 answered they did some writings. He was asked further from his recorded statement. He's 54 years old, then from the family of late Malam Al-Hassan, to which the DW1 stated that no, we did not discuss that. I hold very strongly that the statement made by the defendant and admitted in law is the best guide to the truth of the path taken by the defendant. Where, however, it is challenged, by the defendant, it is the duty of the court to look into the circumstances under which it was made before it is admitted in evidence. The grounds for objection vary from torture, inaccuracies, forged signature, and misrepresentation. All these must be investigated and ascertained before the admission can be relied upon. In the instant case, none of the listed scenarios occurred when the first defendant was arrested and the extrajudicial statement was recorded in the presence of his friend Bala Ahmed, as stated in the extrajudicial statement. The extrajudicial statement of the first defendant is hereby accepted by this honorable court as the truth, having been satisfied, especially in relation to the corroboratory testimonies of PW1, PW2, and specifically the second defendant as DW2 during cross-examination when he replied true. When asked, in your testimony before the court, you informed the court that you and the first defendant have confessed the truth in your statement at NDLEA. From my evaluation of the evidence before the court, the extrajudicial statement was made voluntarily without inducement, threat, or promise from a person with authority. There was a smooth flow in the statement, which was recorded in the presence of the first defendant's friend, one Bala Ahmed. As for the testimony of the defendant in court, this I take with a pinch of salt. I'm fortified in this view by the holding of Dongba Mensem JCA in Obidiezo versus the state 1987-4 NWLR, wherein my lord held that the law and precedents have made it clear that a retracted or challenged confessional statement does not really necessarily exonerate an accused person from the commission of an offense. Denial and an allegation of an induced or implanted confessional statement is one that should engage judicial concern. However, such denial and an allegation must be taken with a pinch of salt. A careful consideration of the circumstances of the alleged compelled confessional statement always reveals some character of voluntariness in the spillage. Some personal details which will be known to the appellant alone often expose this falsity of the allegation of compulsion, end of quote. In the instant case, the first defendant pick and choose the part of the statement that he feels favored him, and he denied the part that he feels is not in his favor. This court fathomed this view from evaluating the testimonies before the court and observing the witness in court. The law is now tried that the evaluation in order to ascribe probative value to such evidence is the primary function of the trial judge, who had the opportunity of hearing the witnesses and observing their demeanor. This exercise enables the judge to determine credible evidence. Credible evidence means worthy of belief, and for evidence to be credible, it should be natural, reasonable, and probable in view of the entire circumstances of the case. Also, the first defendant's statement and the second defendant's statements corroborate each other to the extent I am satisfied, as both documents are consistent in their rationality. There's also NDLEA Sani 1, the tender statement of the PW1 as the witnessing officer, which is consistent with the evidence of both PW1 and PW3. The arresting officer, who is also the recorder of the first and second defendant statements, as earlier stated. As earlier stated in this judgment. the testimony in court as to conspiring with, aid, abet, counsel, attempts to commit, or an accessory to the facts, to the act or offense corroborates the extrajudicial statements of both defendants, and I therefore accept the extrajudicial statements as having been proved by their testimonies. In fact, the law is right on this, that a defendant can be convicted solely on his confessional statement. A court can convict on a confessional statement alone without corroborations once it is satisfied of the truth of the confession. Per Clara Bata Ogumbi JC in Blessing versus Federal Republic of Nigeria to 2015, LPLR, Supreme Court. See also the case of Oyim versus Federal Republic of Nigeria, 2019, LPLR, per Wani Musa Abba Aji, JC, who held, I quote, I must strongly warn and state here that when a confession is made, you are hook, line, and sinker, admitting all the ingredients of the crime and revealing even other things which the world or the prosecution may not know about the crime and all its ingredients, especially where such confession is unequivocally clear and voluntarily without any taint of interference. Thus, it follows that a confessional statement is the best, most direct, and potent weapon in the hand of the prosecution against the accused person and can be a panacea to every criminal mystery and puzzle in the criminal justice system and jurisprudence. Whether a defendant can be convicted based on his confirmation, Musa Datijo Ahmed, Musa Datijo Mohammed, JSC in the case of Timothy versus Federal Republic of Nigeria, 2012, LPLR and Adebayo versus State, 2014, LPLR stated whether it is desirable to have some other evidence other than the confession. Firstly, my Lord held, I quote, a clear, voluntary, and unambiguous confession by an appellant admitting that he has committed the offense he's charged with is often the best evidence against him. Though the law makes it desirable for the court to rely on evidence other than the confession in convicting the appellant, it's not the law that the court relies on such additional evidence in all cases in convicting the appellant, end of quote. In this instant case, where in addition to defendant's confessional statement, where he admitted being the owner of the exhibit and also being the second defendant's master supplier, giving the second defendant the exhibit on Saturday, this evidence was corroborated by the second defendant in his testimony in court, where he stated that the first defendant has a boy who sold taba for him, and on Eid Maulud Saturday, when the boy traveled, the first defendant called him that he should assist him to keep the exhibit as the boy was not around. That in the evening, the NDLEA arrested the second defendant with the recovered exhibit, and he was taken to their office where he was asked who owns the exhibit. There's also the witnessing officer's statement, which gave the genesis of the arrest of both defendants, that the first defendant was arrested as a result of a follow-up operation based on an indictment from the second defendant, who testified in court comprehensively how he collected the exhibit from the first defendant being the real owner of the exhibit recovered. This honorable court holds that the above credible evidence, having been corroborated by the documentary evidence of the extrajudicial statement of both defendants, is extremely relevant for the just determination of this case. In analyzing the evidence reveals that the first defendant's boy having traveled for Salah prompted the first defendant to conspire with the second defendant, aid, abet, counsels, attempts to commit, or acted as an accessory to the act of offense by inciting promises and inducement of the second defendant to collect the recovered exhibit from him, and uses the same method of promise and inducement when the second defendant was arrested and told the second defendant that he will engage the services of a counsel, and that having procured one, the counsel advised that they should both deny knowledge of the exhibit in court. And he told DW2, that's the second defendant, that if he agrees and that they both deny, then he will ensure that they are both granted a release on bail. But if DW2, the second defendant, refuses, he will leave him there at the correctional center, since he has no one to take him on bail. In my respectful view, from the evidence used and my observations of the demeanor of all the witnesses, the first defendant does not appear to be a credible witness. Just like his alias, Sani Babu, meaning Sani Pompous, the name fitted to a T, and I so hold. This assertion of court can be ascertained from the testimony of the second defendant, who testified in court that the first defendant, in a cold-blooded manner, when released on bail, met the second defendant's relatives and solicited for money to release the second defendant, and that the second defendant's wife sold her properties and gave the first defendant the sum of 40,000 naira, which he collected but kept the money without looking out for the second defendant, whose wife, as a tenant in a rented house, was kicked out. The first defendant, it seems, abandoned the second defendant and did not show any remorse to the plight of the second defendant, who were birds of the same feather. Now, from the above testimony, I find the evidence of the second defendant consistent. He appeared to me to be telling the truth. Therefore, the first and second defendants, having conspired with each other, aided, abetted, counsel attempts to commit, accessory to any to act, an offense referred to in the NDLEA Act, is proved. That's section 14B of the NDLEA Act is proved against the defendant as a charge of possession of and dealing in Indian hemp. The mens rea required to establish it is comprised in the words unlawful possession or being in possession without lawful authority, as against unknowingly possessing Indian hemp. Once the substance is proved to be Indian hemp, the burden shifts to the accused to establish that he has lawful authority to be in possession or to deal in the substance. See Galadima JC in Okewu versus Federal Republic of Nigeria, 2012, 9 NWLR Part 1305. From my evaluation of the evidence before the court, the prosecution has proved beyond reasonable doubt that the ingredients of section 14B of the NDLEA Act, having established the alleged offense beyond reasonable doubt, from this analysis, it is obvious that the prosecution has disclosed a prima facie case against the defendant, which has not been contradicted. Consequently, upon my findings above, I therefore hold that the prosecution has proved its case against the defendants who conspires with aids, abates, counsel, attempts to commit, and an accessory to the acts of offense beyond reasonable doubt that the offense of possession of unauthorized drugs has been established against both the first and second defendants. The prosecution, having succeeded in discharging the onus of proof placed on it beyond reasonable doubt, the defendants are hereby convicted as charged. Both convicts are to be remanded in the Potiskum Correctional Center. The matter is for sentencing, but before the matter is adjourned for sentencing hearing, I would like to hear from the convicts.
Has got this one.
Is the defense counsel Okay.
Yes, my lord.
Yes. Yes.
Yes, my lord, we are very grateful with the sound and justified judgment. My lord, the convicts are first.
I prefer counsel. I prefer to hear from the first convict himself, then the second convict before I hear from you.
Thank you, my lord.
Can you speak up so that the defendants and the correctional center can hear you?
Bisa duka alamu lawyer mai gabatar da
correctional center.
My lord, escort, please.
Okay, can you hear Mr. Gani?
Hearing very well, my lord.
Yes, go ahead.
Bisa duka alamu lawyer mai gabatar da kara ya gabatar da hujjojinsa game da wannan batu kuma an same ka da laifi yanzu haka kai mai laifi ne kotu ta same ka da laifi. Dukkan ku kai da shi Muhammad Isa dukkan ku masu laifi ne.
So does he have anything to say before he explains the sentence?
Kana da akwai abin da zaka faɗa wannan kotu mai girma?
Ina da abu da zaka gaya kotu mai daraja mai girma mai nasibi. Ina neman alfarma kotu ta mana sassauci ne jiya za ka zama na
hankali tana rubuta.
Ina da yara guda 18.
Yes, my lord, he said he is a family man having 18 children.
Yes.
Ba wani mai taimaka musu ba da kowa ya ta ci ita ma ta rage ta na asibiti.
He said there is no one to help them.
Ni nake taimaka mata.
He said he is well brother.
Kudin magani wannan na dan bizan nake taimaka mata kuma na ce ta gida.
For medication. The wife and the elder mother. His children and his aged mother.
Is mother still alive?
Mamar ka tana da?
Babu sai ba da kuwa.
Okay.
Ya ta ce ta kare wacce take asibiti.
Okay. Yes.
So you need to interpret correctly.
Thank you, my lord. He said the sister is on admission.
Yes.
Kotu ta tausaya mana cikin halin da muke ciki da iyali. Ba wani mai taimaka musu. Ba na nan yanzu haka ma ne nake ta zirga-zirga. Wacce ya hata gurin ta gudu.
Reading for mercy.
He says something about.
Yes, he is the one struggling to put food on their table.
Yes. Is that it?
Ba bai taimaka yara na za su tafi makaranta da safiyan ƙanana ga shi suna zuwa karatu.
He said his children are going to school and no one assistance.
Yes.
Saboda haka ina neman kotu mai sassauci ta sassauta mun inda Allah ya sassauta mata.
What should be lenient on him?
A taimaka mun da Allah ya taimaka ni kotu mai sassauci.
Correctional center.
Yes, my lord.
Does the second convict have anything to say to the court?
Kana da wani abin da zaka gaya a kotu ne bisa ga hukunci da za a yanke? Ka daga muryanka. My lord, you need temper justice.
Yes.
Ka tausaya mu duba halin da ke ciki da iyalai na ba da mutum. Gidana ya baje ya zama ba kowa. Mata na mata bar gida sai rage kuɗin haya ta koma ƙauye.
Can you interpret?
Yes, my lord.
Can
He
you
said, my lord, he said his families were go to village because of the situation that he is. That is it. So continue. Ci gaba. He need to fight justice, my lord, because his children now is not go to school.
Yes.
Wannan abu da na ɗauki shi a matsayin kaddara. Allah ya karanta mu, ko Allah ne ya riga zancen sire. Na neman abuwa. My lord, he need temper justice again.
Is that it?
Shikenan. Idan na roƙon kotu da ta taso da ta musu sauki da ma'aurata taimaka mu wannan uzuri zama na farko na ƙarshe a gurin. My lord, he need court to temper justice for him. He is the first and last, he said. My lord, the phone battery is low. He changed, he shut down, he changed another phone.
Okay, it's about to run down.
Yes, my lord. He changed
Defense
another
counsel.
phone now.
Okay, no problem. Is that has he finished? Defense counsel.
Yes, my noble lord.
Yes.
Yes, thank you, my noble lord. My lord, the convicts are first-time offenders. The convicts are first-time offenders.
Yes.
My lord, both the convicts are very remorseful. Very remorseful. As the first defendant clearly stated that he is the breadwinner of the family, he has so many defendants who solely depend on him. My noble lord.
Just a minute.
Thank you, my noble lord.
Yes.
The second defendant clearly stated that my noble lord that his member of the family are already scattered because he has been in detention since the day he was arrested to death. Yes, my lord, if this honorable court sentences into the term of imprisonment, even the family of the first defendant too will be scattered and disorganized. Will be scattered and disorganized. And stand as problem to the community in general if they were being spoiled because of lack of guidance because of lack of parental guidance. My noble Lord, even the first defendant, when they were arrested, he spent about a year in the correctional center. And the second defendant, my noble Lord, has been in detention, as I mentioned earlier. My noble Lord.
Just a minute.
Thank you, my noble Lord.
Yes.
The first defendant, my noble Lord, is even diabetes patient. He's a diabetes patient.
Yes.
My Lord, the first defendant made all the necessary attempt in order to see that. He made all the necessary attempt. He made all the necessary attempt to see that one of the relatives of the first defendant, one of the relative of the first or second defendant, show a concern for the fulfillment, show a concern for the fulfillment of the bail of the second defendant, but it's thought to be abortive. But it's thought to be abortive. My noble Lord, this honorable court to consider the relevant authority. Even so, very sorry, I'm not with even my AJA, my Lord. I think it's section 416, my Lord, of the Administration of Criminal Justice Act 2015, my Lord, that the first time offender cannot be convicted for the maximum punishment. So, my Lord, this give a room to this honorable court, my noble Lord. This give a room to this honorable court to exercise discretionary power. To exercise discretionary power to temper justice.
Just give me a minute.
Thank you, madam.
Yes.
Yes, this section, my Lord, it gives the discretionary power of this honorable court to exercise its discretion to temper justice with mercy. To temper justice with mercy upon sentences of the convict, or in alternative manner, law, to even give them the option of fine, or to even give them an option of fine. Thank you, my noble Lord. I urge the court to so hold. Thank you, my noble Lord.
Yes.
Yes, ma'am. Okay.
So, my lord, as part of the mitigating factor,
Yes.
my lord, in sentencing hearing, my lord,
Yes.
the second defendant, my lord, in person of Muhammad Isa,
Yes.
I stand to be corrected, my lord. Muhammad Isa, who is the second defendant, my lord, has suffered enough, my lord, in this matter.
Yes.
My lord, having been bulldozed by the first defendant, my lord, in this matter. And equally, my lord, he has not equally enjoyed the privilege of staying out of the bar, my lord, in order to enjoy the freedom of liberty as derived from bail, my lord. My lord, we urge, my lord, to consider such as a mitigating factor in favor of the second defendant, Muhammad Isa. My lord, we have no mitigating factor to pray, my lord, in favor of this first defendant, my lord. Rather an aggravating factor, my lord.
Let's
Aggravating.
Yes.
My lord, number one, my lord, the role he played, my lord.
Yes.
In dragging the second defendant, my lord, in this matter, my lord, is pathetic. Only he has not been caught, my lord, but an alleged crime, my lord, of thieving from the relation of the second defendant, my lord, because he
Sorry, my lord. Sorry, my lord.
Yes.
My lord. My lord.
Yes.
The prosecution counsel has no right to say anything with regard to this issue, my noble lord.
Yes.
And he cannot intimidate with the court with some other on-call statement, my lord, against the press convict.
Thank you, counsel. Are you through?
My lord, I'm testifying against a convict, my lord.
My lord, he has no right to do so. He has no right. There is no law to that effect, my lord. If he has personal grudges with the first convict, this is not the line that he's supposed to address the court in such a way.
My lord, I have no personal grudges, my lord. It's just the law that is against him.
This is what you have been shown to this honorable court.
Counsel, are you?
My lord, if
just one more, my lord.
Has any previous record of conviction, this is why he will react to say he has. If he doesn't, he don't have any right to say anything. Thank you, my lord.
Please, my lord, that's all, my lord. And we urge, my lord, to administer the full sentence, my lord, against the first defendant. Thank you. No.
The defense counsel,
Yes, my noble lord.
you said the first defendant was incarcerated for almost a year.
Yes, my lord.
When?
From the date of his arrest, my lord, he spent some months in the custody because the kids were on vacation by that time, my lord, as contained on the.
He was not remanded by this court for that long.
As the court pleases.
I just wanted to confirm.
As the court pleases, yes, my lord, because at the time of their arrest, these honorable courts are on vacation, my lord.
Okay, thank you.
Yes, thank you, my noble lord.
Let somebody assist you. Or are you okay standing? Okay. Correctional center, are you still with us?
My lord,
Are you still with us?
my lord, this one we are not hearing all like that one. So we come closer to the phone.
Okay. Can you hear me now?
Yes, I hear you, my lord, very well.
Okay, thank you. Because I want you to listen to enable you to interpret to the defense, to the convict.
Okay, my lord.
Same as the interpreter here in court.
Yawwa, lauya mai gabatar da ƙara yake gaya wa kotu cewa lalle ka sha wahala ka ɗau tsawon lokaci a nan gidan bisa ga yadda dai zaman daga fara shari'a zuwa yanzu, sai ya ce yana roƙon kotu a wajen hukuncin a duba a maka sassauci kamar yadda kai ma ka ce kotu ta maka sassauci, shine abin da ya faɗa. As court please, my lord.
Thank you. Sentence.
As court please.
The court is required, especially in cases involving illicit trafficking or dealing in narcotics, to take into consideration the nature of the drugs involved. In this case, it was cannabis sativa, that the defendants were convicted of having conspired with, aids, abet, counsel, attempts to commit, or accessory to the acts of offense referred to in this act by section 14, sub B. The provisions of the NDLE Act place different regimes of punishment for unlawful possession of cannabis sativa, in contrast with such other hard drugs and psychotropic substances. The court in such cases will consider the quantity found in possession of the defendants when arrested. This enables the court to ascertain whether the defendants are male users or abusers of hard drugs, or someone who is a retail or commercial dealer. By considering the quantity of the hard drugs, it enables the court to assess the extent of harm which the defendant has done to himself as a consumer or to the society as a retail or commercial of illicit hard drugs. Again, the location of the arrest of the defendant is an important consideration, because the court always frowns at a defendant who, as the head of a household, either brings hard drugs home to try to sell it in a neighborhood, or procures another person to either keep it or sell it, as in this case. In view of the fact that in this part of the country, the populace are grappling with insecurity, the court will not likely be lenient with such a defendant or such defendants. This was in relation to such defendants who procures others to sell on his behalf, will also be concerned with the kind of victims he introduces into this nefarious trade. This enables the court to assess the defendant as either incorrigible dealer or trafficker, or a novice who has only been introduced into this illicit business. In this case, both defendants are not novice. The factors which the court will consider are almost inexhaustive, all being in an effort to locate the station of life of the convicts in order to impose such punishment as will meet the justice of his case or of their case. This is the reason why, in my view, judicial sentencing is perhaps the most important aspect of criminal justice and adjudication process, because it is in this regard that the law comes out real to the defendants and to the larger society. A casual attitude by the court to these issues will invariably lead the court to impose a sentence punishment that may be too harsh as to defeat the attainment of the goal to seek the reform of the convicts, and which may invariably impair the attainment of even the goal to seek for deterrence in both the convicts and the larger society. In criminal jurisprudence, the two broad goals of judicial sentencing are firstly, to seek the reform of the convict so that by the time he completes the penal custodial sentence which the court imposes, he will return to the society as a better and more responsible citizen who has respect for the laws of the land. The second goal is to impose such sentence as will serve as deterrence to the other persons who are yet to be caught by the proverbial long arm of the law, who are also involved in similar acts for which the convict has been punished. Whilst the first goal is focuses on the convicts in the dock, the second goal, in my view, focuses on both the convicts in the dock and the society at large, especially for persons who are or may be involved in similar criminal activity for which the convicts are being sentenced. The first convict, by the testimonies before the court, is a devious man taking advantage of the second defendant and abandoned him by getting a lawyer that secured his bail, while the second defendant languished in custody and went ahead and defrauded the second defendant's family by collecting money in the guise of paying a lawyer to secure the bail of the second defendant. The first defendant is so heartless, and from the above testimonies, living large and inducing some boys to, or people with less income or gullible individuals to sell such drugs for him is called calculating and cold-blooded as long as selfish interest is fulfilled. It is damn the consequences. The first defendant, Sani Bagu or Sani Pompous, or as drug lords, are masquerades, living a double standard kind of life. On one hand, like responsible citizens, while on the other hand, a dark side of distributing narcotics and psychotropic substances in the community, thereby sustaining their flamboyant lifestyles from negative income. Such pompous people, it can be implied that the prevalence, nuisance, and destructive social and adverse economic consequences of the misuse of hard drugs are the issues at stake in the NDLEA Act. The right and health of a nation is what is at stake. In the NDLEA Act, the legislators seek a more vigorous and deterring laws to checkmate the daring activities of drug barons. The legislators put in place a specialized agency and arms it with aggressive investigators and prosecutors to go after hard drug dealers against whom stiffer penalties have been put in place. Possession of a wrap or two of Indian hemp is not expected to attract the same punishment with the possession of large volumes or the cultivation of the drug in a farm large or small. The NDLEA Act came into existence to checkmate the daring and ravenous activities of drug dealers and peddlers in order to salvage our nation from the activities of these unpatriotic and merciless drug masquerades. Having listened to the plea in mitigation made by the convicts, as well as the defense counsel and the prosecuting counsel, the court, having taken all that into account in passing sentence on the convicts, I take into consideration that both convicts are first-time offenders before this honorable court. But again, I imagined how many people's lives could have been destroyed if the 387 grams of cannabis sativa wrapped in 97 wraps was not recovered from the defendant's possession. There's need to give a deterrent sentence to send the message that such acts are not acceptable. In the light of my findings, I'm satisfied that the defendants committed the offense under Section 14B of the National Drug Law Enforcement Agency Act, Cap N30, Laws of the Federation of Nigeria, 2004, and accordingly hold that Sani Mohammed Al-Hassan, aka Bagu, and Isa Mohammed, aka Bulama, guilty of the crime as charged. Having said that, hereby sentence the first convict, Sani Mohammed Al-Hassan, aka Hassan Bagu, to 7 years imprisonment. The sentence shall be deemed to have commenced from today, the 14th day of February, 2024. The second convict, Isa Mohammed, aka Bulama, is sentenced to 3 years imprisonment. The sentence shall be deemed to have commenced from the date of arraignment before this court being the day of September 2021. In the final analysis, the seized drugs being dried wheat, which has tested positive for marijuana cannabis, admitted as exhibit NDLEA sign 4 and weighed 387 grams, are hereby confiscated and shall be forfeited to the federal government of Nigeria. The said exhibits shall be destroyed by burning by the NDLEA, along with other judicially condemned narcotics and psychotropic substances at a public function to be organized by the NDLEA. Said event shall be witnessed on NDLS invitation by representatives of the Nigerian Police Force, the Department of State Security Service, and the Nigerian Security and Civil Defense Corps, as well as the print and electronic media and the general public. This shall be the court sentence of the convicts, which sentence is no doubt very light. It was deliberately made in order to encourage the convicts to quickly retrace their steps and return to the society as changed persons. The convicts may not be so lucky if in the future they are caught and charged for a similar offense. This shall be the court sentence. The convicts have 90 days within which to appeal both the conviction and sentence if they are not satisfied with same.
As court, please, my lord. Bisa ga wannan shari'a.
Mr. Salihu?
My lord.
Just give a moment, let's start with the first convict. Just wait 1 minute.
A takaice kotu ta yanke maka hukunci na shekara 7 tun zai fara kirgawa daga yau. Yau ran da aka yanke maka hukunci shekara 7.
Is that all you remember?
Da yake dama hukunci wanda aka same shi da laifi mai kamar haka shekara 25 ne mafi yawa, a mafi kankanta kuma shekara 15, amma kotu ta yi amfani da dama da take da shi yasa ta yanke maka hukunci shekara 7. Idan aka same ka da irin wannan laifi mai kamar wannan nan gaba, ba za ka yi irin wannan sa'an ba, kuma idan ka fita ka zama mutumin kirki ma al'umma. Idan hukuncin nan bai yi maka ba, kana da kwana 90 wanda za ka iya ka ɗaukaka kara.
Mr. Sani, go ahead.
As court, please, my lord. Yauwa, Isa Mohammed. Yau ne kotu ta aka kammala shari'ar ku inda kotu ta yanke hukunci a yanzu. Wanda hukuncin gaskiya yana da mafi karancinsa shekara 15 ne hukuncin. In kuma ya zama wannan ne shekara 25 ne. Amma bisa ga dubi da yanayin kayan da aka samu da kuma duba da kotu ta yi duka da yanayin jawabai da ta amsa. Kotu yanzu ta ɗaure ka shekara 3. Wannan kuma ɗauri ya fara ne daga ranar da aka kama ka. Don haka wannan hukuncin yana da sassauci cikakke sosai akwai sassauci a cikinsa sosai. Don haka sai kai godiya a kotu.
Counsel? Any response?
We are grateful, my noble Lord. Thank you, my Lord.
Thank you. Thank you.
Thank you, my lord.
Correctional Center, thank you so much.
Thank you very much, my lord. Thank you very much, my lord.
For virtual proceedings, this is the end. We go back to the traditional for the rest of the cases.